Hello and welcome everybody to our webinar today on the right to clean air and access to justice. We focus today on how can judgments be enforced. My name is Sebastian Bechtel. I work for the environmental democracy team here at ClientEarth, and I'm sitting next to Ugo Taddei, who is the lead lawyer of the clean air team. And we're also joined by Katherine Nield, who is part of the UK clean air team. This webinar is part of a three-pronged series on the right to clean air, and it forms part of the project Access to Justice for a Greener Europe, which is financed by the European Commission through the LIFE project. We had already one webinar on standing in clean air matters and one webinar on the scope and standard of review, and this then hereby concludes with a focus on remedies. So remedies, in the way that is used here, is the question: what can the court order as a final relief if a court challenge is successful or partially successful, and then also how can these court orders be enforced if there is no immediate compliance with that. And we have separated that topic in three parts. I will be speaking about the general EU legal framework related to remedies. Then Ugo will be speaking about the case law of the Court of Justice on the right to clean air and effective remedies. And then we'll have a case study presented by Katie related to clean air and the legal battle in the United Kingdom. And then we'll have a question and answer session. If this is your first time that you are taking part in one of our webinars, there is no possibility to speak, but we'll have, on your left side, you see a Q&A box, and you will be able to type there, and we will read out your questions and then reply to them in the final part of this webinar. So to get started, the basic legal sources in relation to adequate and effective remedy on the EU level or also on international level. On the one hand, we have certain principles in the European treaties. This is on one hand the principle of effective judicial protection and also sincere and loyal cooperation to the member states. So that's one pillar. Then we have human rights. There's the right to an effective remedy. That forms part both of the Charter of Fundamental Rights under European Union law, but also under the European Convention of Human Rights, particularly Article 6 and Article 13. And then finally, we have an international treaty, the Aarhus Convention, that regulates access to justice, and the EU and all its member states are a member to that as well. And this has also provision that states that procedures shall provide adequate and effective remedies. So this is kind of are the three main sources. And how this then plays out in a bit more detail is member states, when implementing EU law, have procedural autonomy in general, unless there's a specific harmonization. So unless the EU directive or the regulation sets out a specific remedy or a specific procedure. And so this means in particular that member states can define the procedural rules and the remedies that will be available. However, these procedures that are established, this national law that is established and regulates these remedies, must always be equivalent in the sense that the procedure may not be less favorable than other procedures that govern similar domestic actions. And on the other hand, it must always be possible in practice and not excessively difficult for citizens to exercise their rights conferred by European Union law. So this is the general framework in which the Court of Justice will analyze to what extent the national court has complied with its obligation. And this is also the principles supposed to be applied by the national court when applying EU law. This is the first aspect. The second aspect is the already mentioned right to effective remedies. As mentioned, part of the Charter, part of the treaties in the Aarhus Convention. And here we have Court of Justice case law, here in particular also a case that Ugo will be speaking about a bit more detail later, that requires the national court at the same time to interpret its national law in light of the Aarhus Convention, in light of the objective of effective judicial protection. And so this is an additional guarantee when it does its exercise of testing equivalence effectiveness, and then this is the third aspect. And the court has been very clear that all of this is more important if the failure to adopt measures would endanger human health, or if there's the lack of remedies would endanger human health, and this is particularly relevant in the clean air context. Again, something that Ugo will speak about a bit more later. So what does this mean? Well, in practice, the basic principles are, on the one hand, member states should refrain from taking any measures that could seriously compromise the attainment of, including EU environmental law. And that also already applies if a directive is not yet in force. So the member state should not act contrary to it, and that also covers the national courts. And most important for our webinar today, the national courts should always nullify any unlawful consequences of a breach of European Union law. So this is all very high level, but these are the basic principles to be used and to be relied on in relevant litigation. To explain it a bit more, I will use some specific remedies or some specific directives, and these are separated here in kind of three areas, which are the main remedies that are prescribed by EU law. On the one hand, there is the possibility that EU law will require a suspension or revocation or annulment of an unlawful decision, an act. So essentially, the public authority adopts an act or a decision, and the national court will then be required to quash it. On the other hand, secondly, there is a possibility that the court will be required to order an instruction to the public authority if it was under duty to act, but it failed to adopt a particular measure. And finally, there are remedies related to preventing or remedying harm and damage. So to go through them one by one, an example of the first situation arises in the context of the Environmental Impact Assessment Directive. Environmental impact assessment is required prior to the permitting of certain projects that will significantly impact the environment, or where it's likely this will happen. And this has a direct relation, of course, also to air pollution, because a number of activities will lead to quite significant air pollution. Let's think, for instance, of a coal-fired power plant. And here, when we look at the case law in relation to the EIA directive and effective remedies, it becomes clear that the court is speaking exactly about the need to quash relevant decisions, or a permit in this case. So the court has been clear that a national court must take all general particular measures necessary to ensure that an environmental impact assessment is still carried out if there has been a failure to do so. And this applies even if there's already a decision. So if there's already a building permit granted, for instance, and there's the case here in Wales where the court had, subject again to the limits laid down of the principle of procedural autonomy that I've been speaking about earlier, there may be the need to revoke or suspend a consent already granted. And then there's also a case of the Court of Justice that sets out what happens with the activity if the permit has been quashed. I think it's going on. So here you can see one example of how the court is applying these general principles in the context of one act of EU law that is really also relates to clean air. And another example in a similar regard is the Habitats Directive. So there may be that is permitted and that impacts a protected site, a Natura 2000 site, and that has certain protected species or protected habitats. And there may be a failure to carry out an appropriate assessment. And again, the court has been very clear, there's still a need to carry out that appropriate assessment and to make a specific assessment if that activity can still go ahead if there is a risk of deterioration of that habitat. So that is a bit more demanding even than in the context of the EIA directive, because here's a specific test that I've set out here that has to be applied by the national court, and it then has to decide if it has to make an order that essentially says that the project cannot go ahead at all, because it has to test, are there really imperative reasons of public interest that show that the project should still go ahead, are there viable alternative solutions, and so on. And again, there is possibilities that an activity may go ahead, may continue while these assessments are ongoing, but it is also more limited here than in context of the EIA directive. So this shows to you how the court is really using these principles to make EU law effective and ensure that people's right to effective remedies are respected. The second part, or the second kind of category of cases, relate to instructions of orders requiring the adoption of a specific act. And this is something that our ClientEarth team is dealing with quite a lot, so I won't go into any of the details here, but examples are if there's a failure by a national authority to adopt a national air pollution control program or air quality plans, or when it adopts programs or plans that are not of good quality, and there's a fair amount of case law on that. And there's also here the example if a public authority places monitoring stations to test the air quality. Again, that's also related to testing whether there's more measures necessary, such as more stringent air quality plans. And again, there might be a requirement for a national court to make an order on equivalent measure to the public authority on the location of these sampling points. And finally, damages. So anything related to damage that has arisen, there is, so there are three main EU avenues, or three different kinds of procedures that apply. On the one hand, we have the Environmental Liability Directive, which is a specific directive that is, so to say, intended to provide for additional remedies. It applies to damages to water, land, protected species, and natural habitats. But the court has also made clear that it may also cover air pollution if the air pollution causes damage to these elements. So this is one specific regime, and specific rules apply in the Environmental Liability Directive. And there's in practice quite a lot of problems with how it works, but it establishes a specific regime. Then outside of the Environmental Liability Directive, there's again the general principles that will be applied by the court. And here the court has been clear again. This is a context from the EIA context, but it's a very general statement. The national courts must make good any harm caused by the failure, for instance, to carry out an EIA, or the failure to comply with a specific EU law. And then finally, there is a possibility of a personal damage claim. And this is a possibility that is called state liability. It's a specific case law regime and relates to personal damage that has arisen from a breach of EU law. And this has been, it's a bit underused in the environmental context because it's a bit difficult to establish, but it's perhaps a potential third avenue. In practice, one of the specific hurdles in the clean air context, which is our topic today, will always be related to causality. But that's perhaps a topic for another webinar one day. And now I will pass on the word to Ugo, who will be speaking a bit more specifically on the case law of the Court of Justice related to clean air matters, and also talk about the situation where all these wonderful remedies that I've discussed are hindered by the fact that the public authority simply fails to comply.
Thanks, Sebastian, for this good overview of the EU principles. And yeah, as mentioned now, I just want to give you an overview of three key decisions by the European Court of Justice that put the general principles and rights to affect the remedy in the context of air quality. And the first of these cases was the ClientEarth case from 2013. It's useful to give you a brief overview of the background because it really explains why this ruling was essential. When we started litigating in the UK in 2011, the High Court, so the Court of First Instance, refused to grant any remedy. As you may know, in England, administrative courts have a certain degree of discretion on deciding what type of remedy to grant when they find that there is a breach. And unfortunately, in that case, the High Court refused to grant any order because the judge believed that ordering compliance with the limit values and requiring the adoption of a better air quality plan will raise serious political and economic questions, so it was not the role of the court to issue such a strong remedy to ClientEarth. But what is even more concerning is that in that case, the High Court refused to grant also a much less controversial remedy. They refused to also grant a very basic declaration that the government was in breach of the directive, because the court considered that it was enough to have the enforcement proceedings by the Commission. Those are enough sufficient remedies, so there is no need for the courts, the national courts, to do anything. As you can imagine, we were not very happy with this outcome, so we kept fighting and bringing appeals, and we reached the Supreme Court then in May 2013, as a first very important step, issued a clear declaration that the government was breaching the directive. It then decided to stay the proceeding and refer a number of preliminary questions to the European Court of Justice. These were 4 questions concerning the interpretation of Article 13 and Article 23. Some of these related to standing, as you may remember from previous webinars. But the 4th preliminary question regarded what type of remedies must national court provide as a matter of European law when there are breaches of the limit values. And the answer of the Court of Justice of the European Union is very strong and clear. Whenever a member state fails to comply with the requirement of the Air Quality Directive and the limit values, according to the European Court of Justice, it is for the national court to adopt any necessary measures, such as an order, to make sure that the public authority establishes the plan. That is a very strong and important decision, because in many countries, administrative courts will just limit themselves to quashing the previous air quality plan without ordering any action from the authority, just assuming that the public authority will then willingly comply with the rules of European law. The CJEU in the ClientEarth case made it very clear that the national court must do something more and must request the authority to adopt the plan and provide clear guidance to what is needed. The second case, which is really interesting, is the ClientEarth case. This is a decision from last June from the European Court of Justice, and this regarded how authority measure air quality and locate monitoring stations in the city. And again, the Court of Justice clarified that there is a direct connection between having access to justice, having standing, having a real judicial review by the national court, and finally, the third part, the fact that the court must take the necessary measures, such as orders, to ensure compliance with the Air Quality Directive. So again, the Court of Justice clarified that the national judge must issue orders. In this ruling, the Court of Justice remembered that there is the procedural autonomy, but this is limited by the principles of equivalence and effectiveness that Sebastian mentioned previously. And in this case, the Court of Justice didn't need to go any further, because during the hearing, it was clear that the Belgian courts have the power indeed to issue orders. So it wasn't needed for the Court of Justice to clarify what should happen when the domestic rules do not allow courts to issue orders. This question, however, was front and central in the third case that I want to discuss with you. This is a case from Germany, in Munich, brought by Deutsche Umwelthilfe. And in the last webinar, you heard a lot about how Deutsche Umwelthilfe and ClientEarth are bringing litigation in Germany, having intense review of the air quality plan and good rulings ordering the improvement of air quality plan with specific measures to restrict pollution from diesel vehicles. In this case, it's quite crucial, because in Munich, even if litigation started as early in 2005 with the Janecek case, the authorities are still refusing to adopt better air quality plan and comply with orders that became final in 2012. This situation led DOH to bring enforcement action. This was the first time that in Germany an environmental NGO was bringing an enforcement in air quality cases, because usually authorities complied with the order of the courts. This was a rather interesting situation because the only type of remedy that the administrative court had available was the threat of financial sanctions, but are very low and almost symbolic. This is a sanction of up to 10,000 euros that only goes from one budget of the environment minister to the budget of the justice minister. And the court in Munich indeed issued these financial sanctions, and the result was simply that the Bavarian government decided to pay the sanction and then expressly said that they had no intention whatsoever to comply with the court order and introduce restriction on diesel vehicles. That led DOH to try to scale up and push the national court to go further and beyond what domestic rules provide. And they requested the court to issue stronger coercive measures and threat the president of the Bavarian government to go to jail in the event that they continue to fail to comply with the court order and improve air quality in Munich. The situation was quite complex because there is no provision for a jail sentence under the administrative procedural rules in Germany, but there was some possibility of referring to the rules of the civil procedure code. In this situation, the higher administrative court of Bavaria decided to stay the proceedings and seek a clarification from the European Court of Justice of what the national court should do. And the Court of Justice issued a ruling in December 2019, which is very interesting and deals with two key points. The first one is a very general clarification, which is relevant for this case, but potentially for all litigation on air quality and in environmental cases. And the CJEU clarified what are the national court's obligation to ensure the effectiveness of European law and provide effective remedies. So what is the duty of the national court in this part? The second part is more specific to this case. So it regards what are potentially the limits to these powers of the court when the question regards the limitation of the right to liberty. So let's see each of these points. On the first part, the Court of Justice started reaffirming the principles that Sebastian already mentioned. So that in principle, there is procedural autonomy. So it's up to the domestic legal system to provide the remedies, but this needs to be in line with the principle of equivalence and, more importantly, in this case, of effectiveness. So it was clear that the financial sanction of 10,000 euros was not effective. So there was the need to go beyond this. The Court of Justice also stressed that the right to effective remedies has its foundation on fundamental rights, so on the Charter of Fundamental Rights, on the Aarhus Convention, and also on the European Convention on Human Rights. So a situation where the national court is not granting effective remedies and strong sanction to make sure that authorities comply with European law may well breach fundamental rights and human rights. And finally, as already mentioned, the Court of Justice mentioned that this is even more important in the framework of the Air Quality Directive because there is a fundamental interest at play, that is the protection of human health. Applying these principles, the Court of Justice issued what I think is a fundamental ruling, stressing that the national courts have a duty to use the primacy of European law to overcome procedural obstacles in the national system. So the national court must ascertain, taking the whole body of domestic law into consideration, whether it can provide more effective coercive measures to secure compliance by the public authorities. And I'm stressing the part on the taking the whole body of domestic law into consideration, because here is where the Court of Justice is telling to the German administrative courts to go beyond the usual procedural rules that are applying, that is administrative procedural rules, and look all the different procedural rules that exist in one jurisdiction to see if in any other branch of domestic law there are effective remedies that they can use. And here I think it's important to stress the Advocate General opinion, because the Advocate General held that the principle of primacy of European law can well lead to the national court applying procedural rules and adopting measures in situations not provided for by national law. Again, this means that using this ruling and this principle, we can push national courts to go beyond their comfort zone and be a bit more creative in granting effective remedies. And then looking the other part, obviously there are strong reasons why national court must ensure effective remedies, but the Court of Justice stressed as well that there are limits on what the national court can do in light of the fundamental right to liberty. And obviously, when the measure requested from the national court may entail limitation to freedom, there are other fundamental rights that need to be considered and balanced. And these are, again, recognized in the Charter of Fundamental Rights. And there are two key requirements. There needs to be a legal basis for deprivation of liberty that must be sufficiently accessible, precise, and foreseeable. And also, the second part, which is essential, is the proportionality. So before resorting to measures as severe as deprivation of liberty, the national court must consider if there are no less restrictive measures that will enable to achieve the same objective of forcing compliance by the authority. The Court of Justice didn't clarify whether this principle will allow the German court to issue a jail sentence in Germany, because that is clearly a matter of interpretation of the national law in Germany. So we will see in the next weeks and months what happened in Munich. And finally, I think in this ruling, the Court of Justice suggested also alternative options for enforcement, which are quite interesting. The first part is regarding the proportionality. So the Court of Justice seems to suggest that before considering a jail sentence, the German court should be creative and think if they can issue financial penalties which are more effective in forcing compliance. For instance, high financial penalties which are applied a short period of time. For instance, in systems like in France or Belgium, there are financial penalties known as Trent, which are periodic penalty for every day or week of continued breach of European law that can grow up until several, even million euros if the breach continues for a long time. And finally, the Court of Justice suggested that when the national system doesn't allow any other type of effective remedy, there is still the possibility to invoke the principle of state liability. And this is the Frankovich doctrine. So bring the state to court again to claim damages, but as Sebastian already mentioned, there are doubts on whether this would be possible, given the issue to establish a causal link between high pollution and damage for a specific individual. So these are the general and clear principle clarified by the European Court of Justice. And now I'll pass it over to Katie, my colleague from London, to provide you an overview of how, using these principles, we have been fighting the United Kingdom.
Great, thank you, Ugo and Sebastian. You guys are running to absolute clockwork because it's bang on 12 o'clock. I'm not sure I can promise the same. But as Ugo mentioned, I'm going to provide a case study example of how the CJEU case law on this right to clean air has been applied domestically in the UK context, and specifically what type of remedies this has led to in our national courts, how effective those remedies have been at requiring actual action on the ground to reduce pollution, and some of the obstacles that we've faced to enforcing the UK government's compliance with its legal duties to reduce pollution. So just by very brief way of background to provide a bit of the legal context in which these UK cases have been brought, legal limit values for a harmful pollutant called nitrogen dioxide are prescribed by the Ambient Air Quality Directive under UK law, under EU law, and those legal limit values should have been met by the 1st of January 2010. But concentrations of this pollutant, nitrogen dioxide, in towns and cities across the UK have been above this legal limit value ever since that deadline for compliance. And what the law requires is that where these limit values are exceeded, as they have been in the UK, government is required to draw up and implement air quality plans. And these are plans that have to include measures to reduce pollution to within legal limits in the shortest possible time. So as this timeline kind of sets out, since 2011, ClientEarth has been on a really long journey through all levels of the UK and European courts to force urgent action from government to comply with its legal obligation to put plans in place to reduce pollution and protect people's health. So firstly, I'm going to give a brief background to that legal battle and explain what this has led the courts to do. The standard of review that has been applied by judges. So that's kind of going back to one of the previous webinars, but I think it's relevant here. And the legal remedies that have been granted as a result, before I then go on to explain what this has actually meant in practice. So this is a brief timeline on this slide of some of the main stages of the cases that ClientEarth has taken against the UK government. So you'll see that we've taken 3 separate challenges against successive government plans to tackle illegal pollution levels. And each of those 3 challenges has been successful in the courts, with judges finding that the UK government has not been living up to its legal duties with respect to air quality. And each of these cases is interesting in this context because each has broken some element of new legal ground in the UK with respect to either the remedies that have been granted or the standard of review that has been applied by the courts. So I'm going to briefly touch on how that is the case in each of these instances. So in the first case that was launched in the UK back in 2011, and Ugo kind of mentioned this in the context of the preliminary reference to the CJEU that was made by the Supreme Court. But initially, the English courts before that CJEU ruling were really reluctant to provide meaningful remedies. So in response to our first challenge, the High Court was willing to accept that the government was in breach of its legal duties, but it wouldn't go that step further and orders ministers to do anything about it. It said this, as Ugo kind of quoted earlier, and the Court of Appeal pretty much agreed when we challenged this ruling, and ultimately it took that CJEU ruling that Ugo referred to before to push the courts to impose concrete requirements on the government. And this CJEU ruling prompted the UK Supreme Court to change the tune of the lower courts. And this is what it said. So it said that the new government at the time should be left in no doubt as to the need for immediate action to address the issue. And it concluded that the only realistic way to achieve this would be a mandatory order. And that mandatory order required new plans to be drawn up by government within a defined timetable and subject to a set deadline. So the order said this, which is on the next slide, I think. Yes, and so this was a great result in that it provided a hard-edged remedy to point to, and this indeed did result in a new plan being published by the government by that deadline set out in the order. And that 2015 plan was certainly an improvement on what existed before our challenge. It committed 5 major cities in the UK to implement restrictions on the most polluting vehicles, but it still left a lot to be desired, and that plan had some, massive and major flaws in the way that had been drawn up. Without going into too much detail about what they were, firstly, the way government had carried out their assessment of the problem vastly underestimated the scale of it. It applied outdated assumptions about the emissions that were coming out of vehicle exhausts, but it also kind of pushed back the date by which government suggested was the soonest possible time it could tackle the issue. It only modelled future concentrations of the pollutant at 5 yearly intervals and suggested, therefore, that the earliest date it could comply was 2020. So we went back to the court and challenged the 2015 plan on these grounds. And again, the court found that the action being proposed by government wasn't nearly good enough. And so we secured another legal victory, and the court granted the same remedy, another mandatory order requiring a new compliant plan to be produced. So that doesn't sound that interesting. It's the same remedy. It's not a novel thing. But what is particularly interesting about this second case is that the court engaged in a relatively high standard of review when scrutinising the government's plans. So when it comes to judicial review in England and Wales, the court is usually really reluctant to scrutinise matters of a kind of more technical nature, and it's generally pretty deferent to government or public authority experts on how it carries out those technical assessments. But here, the court did actually engage with these kinds of issues. And specifically, it looked at the arguments that ClientEarth raised, and it looked at the way in which government had carried out its modelling of the nitrogen dioxide concentrations in the country. And as you can see here, this is from Justice Garnham in his ruling on the second case. It found that actually the Secretary of State had fallen into error in the way it had modelled pollution concentrations in the country, and the fact that it had only modelled them at 5 yearly intervals, and it had kind of applied outdated assumptions as part of that. So he also provided a really useful and detailed ruling on what air quality plans should do in order to satisfy the requirements set out under law. He kind of went that step further, and he did this by setting out this 3-limbed legal test against which government air quality plans have to be assessed. And this legal test, so I kind of mentioned earlier that the legislation requires that air quality plans set out measures to achieve compliance in the shortest possible time. The judge here, in response to our second legal case, kind of explains a bit more about what that actually means. And he said that this means that compliance must be achieved by the soonest date possible. That's not particularly surprising. But secondly, he also specified that the route by which that compliance objective has to be achieved must also reduce exposure to pollution as quickly as possible. So that means that government should kind of prioritise those measures which reduce pollution quickly in the run-up to compliance. And thirdly, the judge also specified that the plans must not just show that compliance is possible, but they must show that compliance is likely to be achieved. So he then went on to say even more useful stuff about what air quality plans must do. He said this, and basically what this conclusion means is that cost should not be a determining consideration when the government is determining how quickly it can and should achieve compliance by the measures set out in its air quality plan. Costs can only be considered when choosing between two equally effective measures that result in the same kind of pollution reductions. So why this is interesting is that, as well as granting another mandatory order requiring a new plan, the judge engaged with a more detailed standard of review than would usually be expected. And the resulting ruling set a really, really high bar as a result, and set quite constrained parameters within which the government's future air quality plans must be produced. So when the government did publish the updated court-ordered plans in 2017, it was these tests that were the tests against which that plan had to be scrutinised. And I can't actually see the slides anymore, but maybe I'll just keep talking. Oh, there we go. Oh, there we go. Yeah, so it's these quite strict legal tests that the plans had to be scrutinised against, and that's exactly what ClientEarth then did. So the 2017 plan was published. We looked at it against these legal tests, and we considered that it didn't meet them. So we brought another challenge, as you can see on this timeline here. So our third legal challenge was launched after the 2017 plan was published in July. And this was on the basis that this 2017 plan actually kind of failed to set out any measures really at all for huge swathes of the country in which illegal levels of pollution were persisting at the time. And those areas of the country included Wales, as well as a whole suite of other local authority areas in England, in which pollution levels were modelled to be illegal in some cases for many years to come. So in response to this challenge, again, the court agreed that the plan did not live up to the legal tests previously set out by the court. And hey presto, it granted the same remedy as the previous challenges, another mandatory order requiring another plan to be published by the 31st of October 2018. But what's even more interesting about this legal challenge and the remedy that was granted is the additional provisions that were set out in that court order. The judge gave the mandatory order a rather kind of useful gloss from our perspective, in that it went a step further to recognise ClientEarth's role in enforcing that remedy. So in the court's judgment on remedies, it said these things, and I can shamelessly blow ClientEarth's trumpet here, as I hadn't actually joined at the time, so it had nothing to do with me personally, but the court did explicitly recognise the valuable role that ClientEarth had played in keeping an eye on the UK government's every move, and explicitly recognised the fact that the court itself couldn't do that job fully. And this was all recognised in the context of the urgency of the need for action to protect people's health, and the fact that evidence points to tens of thousands of people dying prematurely linked to high levels of air pollution in the UK. So in light of all this, the court adapted the usual remedy to make it easier and to make it quicker for ClientEarth to continue to fulfil this monitoring role. So on the next slide, there are some more kind words about ClientEarth, but also alludes to how the court adapted that remedy. Well, what the court did was it provided ClientEarth with what's referred to as an extended liberty to apply with respect to the lawfulness of the plan, the court-ordered plan produced by government. Basically, what this extended liberty to apply does is it does away with an initial and sometimes time-consuming stage of court proceedings, whereby applicants have to apply for permission to then subsequently bring a claim. And by doing away with that stage, or the need for ClientEarth to kind of go over that hurdle, it meant that ClientEarth could instead, if it saw issue with this final plan, take the claim quickly and directly to the court, and therefore negate any further delay. And as underlined here, this was a wholly exceptional kind of course of action for the court to take. This initial permission stage of proceedings is usually there to do away with the risk of vexatious or challenges. And it was in the context of the government's bad behaviour, ClientEarth's useful behaviour, and the threat to public health, that the court kind of took it on trust that ClientEarth would not abuse this power and would not take purely vexatious challenges under this liberty to apply. So on the next slide, for those of you who are interested, it's a small extract from what the court order actually said. So you can see there, liberty to apply on notice as to the lawfulness of the final supplemental plan. So where has this actually got us to? So the whole point of us taking legal action is to force action on the ground to reduce pollution and to protect the people's health in the UK. Has this actually been achieved? Has what we've done actually made a difference? Well, definitely, yes. Each kind of court-ordered plan that has been published in response to these court orders has been an improvement on the last, with more action and more funding committed to tackling pollution in the UK. Specifically and most notably, as part of these court-ordered plans, a number of towns and cities across the country have either already or are going to put in place clean air zones, and that's what these CAZs refer to here. And so it's these clean air zones are areas where the most polluting vehicles that don't meet set emission standards are restricted from entering. And the introduction of these CAZs is a huge step and a major part of the solution to a problem that primarily comes from road transport emissions. So by way of example, both Leeds and Birmingham are due to introduce their clean air zones this year, with Bath, Newcastle and Sheffield and a number of others to follow either later this year or next year. And it's safe to say that this wouldn't be happening, or at the very most it would be happening in a much more delayed fashion without the remedies that we'd secured through the courts, and as well the threat that similar action could be taken in the future. But it's not all completely rosy. There's still a lot left to be done in the UK. So 36 out of 43 reporting zones in the country still do exceed legal limits, according to latest government figures. And there are areas that remain in breach of these legal limits, but for which there's still no plan to actually tackle the problem. There are no measures kind of finally committed to reduce pollution. So why is it that almost 10 years after we've first launched legal action, has the problem not been solved more quickly? Well, there are a couple of key reasons why we're seeing these kind of delays still. Firstly, and very frustratingly, as part of the kind of two latest court-ordered UK plans, rather than implementing action on a national scale, the government took the decision to pass the burden of coming up with pollution reduction proposals to individual local authorities. And it brandished this air pollution problem as a local issue, despite the fact it's happening all over the country. And this has meant that over 60 local authorities in England and Wales have been directed to propose solutions for their areas by specified government-imposed deadlines. And so the national plans that were produced as a result of these court orders were, in a sense, kind of plans for lots more local plans. And this has unsurprisingly led to some difficulties for ClientEarth in carrying out that monitoring role that the court has recognised that we're well placed to do. It's scattered the legal targets for challenge. So there are many different individual plans coming out of many different local authorities at many different times. And it's difficult to keep track of whether everyone is doing a good enough job. It's also brought local politics into the picture. So local authorities are struggling to make these decisions because sometimes they can seem quite politically unpalatable to restrict drivers' behaviour. And there are also issues as to resourcing and funding and tensions between national and local government in this respect. So this passing of responsibility was not an issue the court was willing to engage with, and these plans for plans were deemed compliant. But as there is no kind of court deadline to hold these local authorities to account against, this has all kind of contributed to delays to action on the ground. And there are some key local authorities, as I said, that still don't have plans in place. Secondly, much of the local authorities' justification of whether and how the measures they're putting in place are good enough relies heavily on a technical assessment of the air quality impacts of those measures. And, you know, this is definitely good in some ways. Action should be evidence-based, but it's also challenging in others. They're difficult to scrutinize, both by people, by NGOs, and also by the courts. And a lot of deference is kind of applied to experts doing their job properly. So, and also to mention finally, there's the issue of cost. It's so obvious it's almost not worth a mention, but you know, taking enforcement action is costly, and that's an obvious obstacle to enforcement here. So finally, in light of these obstacles, ClientEarth has been busy outside of the courtroom too, and the kind of alternative extrajudicial means of imposing pressure for action are also very important in the UK context and also elsewhere. So how have we been doing that? We've been doing a couple of key things. We've been engaging with local authorities through consultation responses, through direct correspondence with individual authorities, and in this way, we've been highlighting what their plans have to achieve, and highlighting that if they don't, there is a credible threat of legal action. And obviously, the powerful remedies that the courts have granted in response to previous legal challenges has made this job easier. Secondly, we're also, you know, busy in trying to increase public awareness and political pressure to action, both on a national scale and a local scale. So engaging with the media, but also engaging with members of the public, as well as businesses too. I'll leave it there because I've already gone over my time a little bit, and I think there is a summary slide. I don't know whether I'm the one who's doing that, but...
Thanks, Katie.
Okay, thank you.
Yeah, I just wanted to close this final webinar with three key takeaways. I think the first thing that we have seen today is that under European law, national courts have a duty to provide effective remedies. And this is all the more important in air quality matters because there are serious danger for human health. Unfortunately, national procedures are often ill-equipped to address failures to act of public authorities. National courts are usually reluctant to order direct action of authorities, or much more comfortable in other type of challenges that are simply quashing unlawful decisions rather than ordering positive action and positive steps to be taken. So that presents a challenge for individuals and NGOs who want to bring litigation in air quality matters, because often we don't have easily available strong remedies that we can rely to. But I think that the good news is that the principles of European law and the rulings of the Court of Justice of the European Union provide a whole tool set that we can use to overcome national procedural barriers and try to obtain more effective coercive measures. We have seen that this has been the case, for instance, in the UK, where in the final judgment in 2018, the High Court granted an exceptional remedy of liberty to apply to make it easier for ClientEarth to go back to court and keep playing the essential role of a watchdog. We're hopeful that we will achieve something similar in Germany now after the CJEU ruling, and I will invite all of you to try to do the same when litigating before national courts, because we can really make a change if we push courts to be more ambitious. So that's all for today's webinar and this series of 3 webinars on air quality. Here you have some contact details if you want to ask follow-up questions in future. Just remembering you that we will have further webinars on other topics like climate change and the Habitats Directive in the coming weeks and months. And also on the 13th of May, our colleagues of the Environmental Democracy team, including Sebastian, are organizing a EU-wide conference on access to justice in environmental matters. So here you have the details if you want to register. And now we still have some time to address some questions.
So we have a first question here, which is, what will be the consequences of Brexit be on air pollution plans, legislation, and UK court case law? Perhaps that's one for Katie to answer.
Yeah, looks like.
Yeah, okay, yeah, happy to answer that question. I'm not happy with the answer itself, however. Firstly, it's worth stressing that the law itself, so these legal limit values that are referred to, and the obligations for the UK government to have a plan in place to meet those limit values, that law will not fall away as a result of Brexit directly, and nor will the impact of the case law that we've relied on domestically so far. That has been carried over. What the concern is the risk of divergence from that going forward. So firstly, there's kind of no commitment from the UK government so far to not regress on the standards that exist in UK law as a result of the EU directive. So there is a chance that those legal limit values could be weakened in the future. And also, secondly, the withdrawal agreement bill that was passed recently in the UK provides explicit power for ministers to order courts to diverge from EU-based case law. So all that lovely, juicy domestic and CJEU case law relating to air quality, and there is technically a power that ministers could tell courts to ignore it. Obviously, we'll have to wait and see whether and how that's exercised. But as I said, it's more the risk of what's going to happen going forward, and there's a huge amount of uncertainty.
Thank you, Katie. There's also the second question also relates to the UK. Is there a possibility for monetary sanctions for non-compliance with judicial orders in the UK?
Yeah, so I mean, luckily so far, the government has actually published plans in line with the deadlines set out in orders, but failure of ministers to comply with the terms of a court order is a kind of punishable offence and can be subject to personal fines, I think, from memory. I don't know. There's also kind of an interesting issue more broadly than that too, as is a post-Brexit one as well, in that obviously the UK has ongoing infringement proceedings against it with respect to its non-compliance with these EU limit values. And it's now outside of the jurisdiction of the European Commission and the CJEU. And the body that's been set up to take its place, or will be set up to take its place, would not have the ultimate kind of clout and the ultimate power to impose the type of monetary fines that the CJEU could do prior to Brexit. So the general kind of national level governance and enforcement is also going to be a massive gap following Brexit.
Thanks, Katie. And then we have a third question on whether we can affirm that the principle of direct effect apply to the air quality directive. So whether it expressly or implicitly confers individual rights. And yeah, I think that's indeed the case starting from the Janecek case and then the ClientEarth preliminary ruling, and finally the CRINES case. In all three cases, the European Court of Justice confirmed that the ambient air quality directive contains sufficiently clear and directly applicable provisions that can be relied by individuals before national courts to ensure that national authorities comply with the directive. And I think, yeah, on this point, I think it's also interesting to know that in most of the countries, the directive has been transposed into national laws. So you can rely directly on the directive, but also on the national provisions implementing it.
And we have another question here, which is, have you had experiences in non-EU countries? I'm from Turkey, I'm from HEAL, Health and Environment Alliance, would really love to create a joint movement around it.
Thanks for the question. So at the moment, all of our cases has been before national courts within the European Union. There are some interesting developments that we have seen definitely in Turkey and also in the Western Balkans, where to a certain extent there is starting to be some harmonization with the European Union acquis. So yeah, definitely get in touch if you want to know more about Turkey. We are not directly working there at the moment with our ClientEarth work, but we'll be happy to hear more about your ideas and to see whether we can help.
Okay, I think these are all the questions so far. So perhaps we are also already 2 minutes over time. We conclude here. And of course, as Ugo said, you can also send us an email afterwards if any other things may come up. Here we have a final slide that refers you to some of the material that we have produced as part of this live project. We have prepared a guide on access to justice and environmental matters that's available on our website. We have some country-specific legal text toolkits, and also all our webinars, including this one. We have recordings of them, and we put that on YouTube. So there's a link there, and you can sign up for updates for anything that will come up. And as Ugo mentioned, will be new webinars. There's our EU-wide conference, and we also have some more trainings coming up in some EU member states, in particular in France, in the next weeks and months. So thank you very much for your attention, and have a great day.